I'm Gail Kent. I work for Facebook and I look at global policy on surveillance and law enforcement and cybersecurity. But Peter's asked me to moderate the first panel looking at the intersection of law enforcement, intelligence and military in this space. And as he's outlined, this is an area where certainly from my perspective, and I've been looking at this for a long, long time, there hasn't been a huge amount of debate. So I'm going to introduce the panelists and then we're going to have a conversation. We're not going to start with like introductory remarks. I think there's lots of spaces to fill. So first we've got Susan Hennessey, who I'm sure is familiar to a lot of you. She's an ex-attorney at the NSA, but now she is the managing editor at Lawfare, which is responsible for a lot of the debate that we see on issues. And I think that it's probably something that we increasingly have all turned to look at in the last few years, is debate around surveillance and national security has become more and more prominent. Then next I've got John DeLong, who is a Harvard fellow, but also got an interesting title at the NSA, like Director of Compliance. So I was like, compliance with what? Sounds like particularly scary, but 2009 to 2014. And you're also a maths and computer specialist. And you've been looking again at this area for quite a long time. And then Scarlet Kim is both, you're a bit like me, you're US and UK trained, a US trained lawyer, but also a UK solicitor at the moment, and you work for Hennessey International, and has also looked at this area internationally as a legal advisor to the International Crime Court. And then lastly, but certainly not least, and somebody with an equally impressive title, you were Philip Breedlove, who was Supreme Commander. I would like to have that title in the future life for the US Command for Europe and NATO, and you were responsible at one time for 105 countries, which and I absolutely understand the challenges of that. And I also saw from your biography that you did 3,500 hours flying in the F-16. So they've just announced a US general election, so I'm wondering if you could just take me back straight away at the end of that. Would definitely help. But kicking off and looking at intelligence and law enforcement, and this has been, I think, in the news, particularly in the US, at the end of the Obama administration, when he changed the regulations looking at what intelligence sharing looked like between intelligence and law enforcement. So Susan, I wonder if you could start off by telling us what does that look like in the US at the moment, sharing of information between intelligence and law enforcement?
Sure. So I think there were well-known changes that were made at the end of the Obama administration, but sort of to understand the general lay of the land, we probably have to go back to pre-9/11. As Phil mentioned, there are different legal authorities for the military, for intelligence, and for domestic law enforcement. Our prior construct was pretty much everyone sort of unto their own. Intelligence was not broadly shared. It was only shared in relatively limited circumstances for important reasons of privacy, to prevent abuse, and to ensure Americans' constitutional rights were honored. That had significant advantages, not just privacy and civil liberties protection, but also the protection of classified information and others. And one major drawback, which is that law enforcement occasionally didn't see things that they needed to see, or we were insufficiently connecting the dots, not just between law enforcement and the intelligence community, but actually within the intelligence agencies themselves. 9/11 was sort of the catastrophic embodiment of that failure, and so a series of post-9/11 reforms were implemented. So the pendulum is over here, and we swing wildly in the opposite direction. So this effort to deconstruct or pull down the wall between intelligence, the intention was really to lead to more operational sharing. The notion of being that it was as bad to be late and right as to be fast and wrong, right? That there really is a need to share this information at an operational speed, while at the same time not just protecting privacy, but also only sharing information you need, right? Quality controls. So that sort of brings us to where we are today. So of the post-9/11 reforms, some were related to the information sharing. Others also included designating part of the FBI part of the intelligence community. So the FBI sort of comes within that broader umbrella of the 16, 17 intelligence agencies. So the way it essentially works now is that only speaking from the intel to law enforcement direction, each intelligence agency collects information pursuant to its own lawful authorities. Once that information is collected, a series of protections are applied. It goes through a minimization process. Now, in the news, there's been a lot of focus on masking and unmasking. It's important to understand that minimization is a process. Masking is one possible outcome in that process. But essentially, it's a series of protections undertaken pursuant to the Attorney General's guidelines and some statutory obligations to process information before it's ultimately disseminated out. So what ultimately goes out to law enforcement and other intelligence agencies is not that raw streams of signals intelligence or other forms of intelligence. It's a process sort of product. The rules changes that occurred right at the January of this year only relate to intelligence collected pursuant to 12333. So in the United States, we have sort of two authorities. This is grotesquely oversimplifying, but whenever we're collecting for foreign intelligence purposes of a foreign target, but within the United States, so from a United States internet service provider elsewhere, we operate under the FISA statutory framework. Whenever the United States is collecting abroad, again, foreign intelligence for foreign intelligence purposes, foreign individuals, they're operating under the 12333 framework. So that's within the president's sort of commander-in-chief powers. So the constraints are a little bit different, although they are similar in many important ways. So those changes, those information sharing changes, were really about who is allowed to access raw signals intelligence collected under 12333. They got a lot of attention and sort of concern, in part because we had a new president who caused a little bit of anxiety in people who watch this intelligence space. The important thing to understand is that those guidelines didn't change substantively what we were allowed to collect. They didn't change who was allowed to see what information. And what they changed was the group of individuals who are allowed to apply those initial minimization rules. Right, so instead of having it first go through the NSA and then out to everybody else, there was a broader designated group to sort of do that first initial screen. There are also a number of constraints that I think are less visible to the outside in terms of the intel to law enforcement info sharing. So just because there are formal streams, there are also other ways in which it becomes difficult for law enforcement to access or use intelligence information in practice. The most significant is that you can't use often intelligence information in court. So we have CIPA, which is the Classified Information Protections Act. That works in some cases to sort of protect sources and methods, but there's lots and lots of fights between the intelligence agencies and the Department of Justice or the FBI, who of course want to prosecute and use this information. That led to a practice in the past known as parallel construction. That's where certain intelligence information would indicate a crime was being committed. You didn't want to have the person prosecuted in court and reveal sources and methods, so you tipped the FBI maybe you should be looking, right? You would recreate the case using other methods. DOJ has said that they no longer engage in that practice. It's come under a lot of significant criticism. But I think sort of the broad thing to understand is this is all being motivated by a nightmare scenario, which may or may not be grounded in reality. So nightmare scenario number one is law enforcement doesn't get the information that it needs. Nightmare scenario number two is law enforcement has access to intelligence information, sees evidence of some kind of horrific crime, but the guidelines are such that they aren't allowed to take action. So those really are the animating principles that lead to lots of somewhat strange rules.
Do you talk about nightmare scenarios? Scarlet talks about there are formal and informal protections. What do you think? Are there privacy nightmare scenarios there as well?
Sure. Well, I just want to step back for a second because usually when I begin a discussion about so that means that when we scrutinize state surveillance, we consider that through the lens of interference with international human rights, so rights built into the international human rights framework, and how a state justifies that interference in accordance with international human rights standards. And one sort of subpoint to that is that we naturally focus on the rights to privacy and freedom of expression, but we also consider the impact of surveillance on a range of other rights. So for example, where a government relies on a novel surveillance technique and fails to insufficiently disclose that technique when relying on evidence in court, for example, that may impact due process rights or the right to a fair trial, which is something that Susan alluded to when she was talking about the implications for the use of foreign intelligence information in a criminal case. And then national or regional frameworks. And in the U.S. context, this is quite relevant because the U.S. is particularly allergic to international human rights framing, although there are obviously analogous principles under constitutional law. And then the other issue is that I think from our perspective, there are a number of ways in which U.S. surveillance falls short of international human rights standards, particularly foreign-facing surveillance. But there are other instances where the U.S. is what we would consider more of a standard bearer. So, for example, our federal wiretap law, Title 3, provides really strong protections, at least for domestic interception of communications. And the reason why I started with this framing is because I think one of the main themes related to sharing is this ability of comparing regulatory frameworks and understanding, in particular, the standards related to transparency, safeguards, and oversight that apply, especially when you're moving from one framework to another. And when you look at the vector of information moving from intelligence agencies to law enforcement, you're naturally moving from a framework where there's less transparency and generally weaker safeguards and oversight than in the law enforcement context. And obviously that raises concerns, and the main concern there is whether or not you can apply the stronger protections built into one framework when information is collected and then shared from a framework that obviously has sort of weaker safeguards built in. So Susan mentioned, sorry, I have a bit of a lingering cough, so I apologize for that. Susan mentioned the Executive Order 12333 framework, and I just wanted to use that as an example to look at the way in which information is disseminated and some of the particularly Fourth Amendment implications that arise in that context. So I think from a very general point of view, from a civil liberties, human rights perspective, there are, in general, transparency and oversight challenges raised by the Executive Order 12333 framework. The first is that there's not as much meaningful congressional and really no meaningful judicial oversight because the procedures as to how information is collected and then shared are devised by the agencies themselves and then approved by the Attorney General. And then in certain circumstances, the procedures themselves then become extremely critical to understanding what the safeguards are that are built in. And I think that there are a few agencies where we're a little bit more murky on what those procedures are. So I think like the DEA and Treasury, Department of Homeland Security have yet to finally establish those procedures. The NSA does have a set of procedures that are publicly available, and I'm going to talk a little bit about those. But Susan and John, I know you have a lot of experience working with them day to day, so if you have any clarifying points, I actually really welcome those. So I just want to look at quickly first, and I'm going to go pre-January when the dissemination landscape was somewhat changed by the Obama administration. But looking first quickly at what information can be shared. So I think there are two frameworks that we look at in looking at what kind of criminal information related to criminal activity can be shared from the intelligence agencies to law enforcement. So first, there's this 1995 Memorandum of Understanding between the intelligence agencies and the Attorney General, which basically states that the intelligence agencies are required to share information about certain categories of crimes with the Department of Justice. And I think one of the concerns for us is that the categories of crimes there are not necessarily limited to national security or what we would consider serious crimes. And one example is that one category is violations related to U.S. drug laws. And the scope of those violations, I think, can be quite broad. The other framework is USSID 18, which is an NSA directive outlining how the NSA must treat the information of U.S. persons. So that permits, it's not a requirement, but it permits the intelligence agencies to disseminate information to other agencies where it's necessary to understand foreign intelligence information or assess its importance. And underneath that category, the NSA, for example, is permitted to disseminate information related to potential criminal activity to the law enforcement agencies without a limitation on the scope of the criminal activity, the seriousness of the crime. So the particular rights implications, I mean, under the Fourth Amendment, I think we're all familiar that when law enforcement conducts surveillance without a warrant, the government generally can't use the fruits of that surveillance as evidence in criminal cases. And notice under the Fourth Amendment is a really important mechanism for affecting that right. So it allows defendants to really test whether government evidence is actually obtained lawfully. And there was reporting that in the past the government was interpreting an exception to the notice requirement when information was shared that was collected under Executive Order 12333 with the law enforcement agencies. And under that exception, the government contended that it didn't need to provide notice where evidence is derived from Executive Order 12333 surveillance. And a couple of the red flags that it raised, I think from a civil liberties perspective, is first, more holistically, the notice policy itself was formulated in a non-public fashion, which I think is quite dangerous because the public wasn't aware for quite some time that that exception even existed. And then I think the exception in and of itself, it endangers both judicial review of more systemically of a particular surveillance program under Executive Order 12333, but then also at an individual criminal case level, when the exception is applied, it's very difficult for a criminal defendant then to challenge kind of the source of particular streams of evidence if it's coming from Executive Order 12333. Now, in terms of the developments that Susan mentioned in the post-January landscape, I take your point, actually, that the scope of collection, its protections and uses haven't changed substantively. I think from a civil liberties perspective, the concerns we would have is that when you increase the number of agencies that have access to raw signals intelligence, you're increasing the number of agencies that have to apply particular safeguards. So it obviously increases the breadth of oversight that's needed. And then the other concern there is that when you have an agency like the FBI that has intelligence and law enforcement components, the question there is, so under the 1995 MOU, for example, there's a provision that states that intelligence components of agencies should also share information related to certain categories of crimes with law enforcement component. And I think there's a question there about the particular safeguards built into those types of agencies when that kind of sharing occurs. And I'd actually be really curious, we may disagree on the appropriateness of the scope of collection, but I think we might agree as to there might be some shared ground as to the types of kind of safeguards that need to be built in when you expand the sharing, at least at the raw intelligence level, and kind of what additional safeguards and oversight you need to be building into these agencies, particularly those that share both intelligence and law enforcement function.
So one quick corrective on the change in the legal interpretation. So that was related to the 702 program. There was a DOJ opinion or legal opinion that essentially said this derived. And the 702 has a statutory notice requirement, and there was a legal opinion that derived from the bulletin. And actually, I do think gets to one of the points we were making about 12333, which is 702, because it falls within a statutory framework, there's a judge, there's a law, right? There's something sort of external that is built into that control. Obviously, similar issues arise in hearings and the guidelines of 12333. So in the 702 context, there's a judge that you have to answer to that says, no, that's not what that provision means, and then there's sort of an external mechanism. If the same issue arises in the 12333 context, it's there is no external, right? There certainly is an effort to bring things in line, but whenever we think about, hey, how can we make 12333 more rights protective, or what are sort of areas, those are good examples of, hey, where have we seen course corrections in the FISA context, and how can we bring that to bear in the 12333 context. The real challenge here is that it's not just a choice the executive branch made, it's a choice in the Constitution. This is the separation of powers. So there are really complex, whenever we start to regulate into the 12333 area, there are underlying very powerful reasons why we don't allow the legislature to make laws in this space.
And we're going to come back to things like oversight and transparency, but we've just, like, you both have just explained how complicated this is in a domestic purpose, in a domestic context, so intelligence and law enforcement sharing, and the lack of transparency that there is sometimes around that to a normal member of the public. Now we're here talking about mutual legal assistance and international and cross-border data. What does that then look like internationally when you start trying to share across borders?
So my job is to make it more complicated.
Your job is to make it more complicated, and then Phil's going to clarify it, how we fight ISIS.
Phil's the cleanup.
Yeah. Yeah.
So kind of to build on all that, I wrote down 5 points that I think, if you're thinking about cross-border or nation-to-nation sharing, that at least in my former role as director of compliance, and just to pick up on that, a lot of that was compliance about the rules that relate to collection of information in the first place, and then handling and dissemination. So these are the types of situations. The first is, a lot of people talk about data sharing, getting data from country A to country B. When push comes to shove, what really is an issue is use, right? If you're country A, what is country B going to do with that? And on top of that, how is country A, let's just say the US, going to be assured that country B is actually handling and using the information and whatever was agreed upon? So that's kind of first and foremost. The second is, right, and Peter was talking about, the various different countries that have different divisions between law enforcement, intelligence, and military. But typically, when you're going from one country to another, at least my experience was, you tend to go to your peers. So intelligence will go to intelligence, law enforcement to law enforcement, military to military. When you start crossing the streams, not to use a Ghostbusters analogy, but when you start crossing the streams and going from U.S. intelligence to, a country B's law enforcement, it gets dicey. One, because you have two communities that generally have different norms, customs, and terminology, and also the country B's intelligence services will say, well, wait a second, we need to know about this. Why don't you just give it to us, and then we'll work it out, because we also internally, in country B, have a lot of discussions. Third thing, we often talk about moving data, but sometimes it can be more privacy protective or more efficient to move people, move expertise, seek expertise, move capabilities, move technology, or share technology. And I think sometimes that gets lost in these discussions about privacy and security, which is, it's not just at the end of the day about how much data is moving from country A to country B or from law enforcement and intelligence, but how are capabilities and technology being used. The fourth thing that you think about a lot, especially from the U.S. perspective, coming under 12333, which is, there's a provision in 12333 called indirect participation. I used to have this memorized, but I'll have to read it, which essentially says, no element of the intelligence community shall participate in or request any person to undertake activities forbidden by this order. So in a shorter set of words, I probably can't pull this off, basically says you can't ask someone to do or participate in something that you couldn't do yourself. So this is the you can't, and it's person, it's not foreign country, it's not U.S. contractor, it's not whatever. Basically saying anytime you're engaging, i.e. sharing data or receiving data becomes a big issue, you have to make sure that it's not an activity, that you are forbidden to undertake.
And what assurances do you have that that is the case? So how would you know that, going back to your first point, that you're asking someone to do something that they are not going to do that, or the consequences?
Yeah, so this comes down to, you hear about the Five Eyes, and you hear about different levels of trust, and that's why typically intelligence services work with intelligence services, because they know that a year from now you're going to be working with that same intelligence service, and if you found out that they broke that trust, or you found out that they can't produce the evidence that they actually handled the information the correct way, then they know that there's going to be consequences. I could talk a little bit more about that.
I think there's also, and this sort of gets at the concept of peer constraints. And this is the ways in which different countries' laws constrain one another. And what ends up happening is the most protective law is applied. Anyone who works in the corporate space that has, multinational corporations, you know that you have to comply with the law that's the most restrictive and onerous. I think it's safe to say the same occurs in the government and intelligence context.
And even like receiving information, you'll ask, where did this come from? And if the answers are clear and they make sense, then that's one thing. If people are breaking eye contact with you and they won't tell you, then typically that information will not be allowed to be received. Right? There's no legal, counsel on the U.S. side that's going to say, yeah, we don't really need to know too much about where that information came from.
And is it enough to know, like for you, is it enough to know that that is the case, or?
Well, I think there's two vectors there. So there's the question of the receipt of information and kind of asking what kind of human rights implications or concerns might be in the collection of that information prior to the sharing. But I think the other vector that's somewhat more ignored is the question of how do you assure when the information is sent out, which is the point that John was making exactly. How do you assure when the information is sent out that it's not then going to be used for purposes that would be considered unlawful in the country where it was collected or under, for example, international human rights standards. I think that there are a number of ways in which we could probably strengthen that regime. So, for example, you could have, the US-UK, the UKUSA agreement, the UK-US agreement, which governs the Five Eyes Alliance, is not, the modern iteration is not made public. And I think there's a question there as to whether or not you could make the basic framework public, whether or not you would want to build in directly into that agreement sort of more transparent safeguards and assurances as to the conditions under which you would share information with another party. And then I think aside from the agreements between countries, there's this question about whether or not you want to have some kind of primary domestic legislation that also lays out clearly what kind of protections you would put into place before sharing information. And then I think a third thing that might be useful is to consider the role of oversight bodies. So I think with a lot of intelligence sharing agreements, there's a prohibition against sharing of information related to that agreement with third parties, and that often includes oversight bodies, intelligence oversight bodies. So if you could open up some of the scrutiny that oversight bodies might apply to domestic foreign intelligence collection to the sharing process, you might be able to add a layer of both transparency and scrutiny that could be useful to assure that the information is complying with particular safeguards.
So this is one way. So I think that makes a lot of intuitive sense. The problem is that it's really challenging to implement because whenever you have a rule that essentially says for anyone who accesses this information, there has to be oversight, transparency, and then of course there's the existing training requirements. Right, so when you talk to the inspector generals or other things, and they say, okay, so you're also going to comply with all of the requirements for training, right? And they say, okay. And they say, but now that there's a requirement that somebody oversee you, who is going to oversee you, and then who's going to oversee their access to you, right? So this is an area in which laws or provisions of law that can look just absolutely common sense on its face, I think it would be a real frustration for the privacy community to think, who wouldn't, this is the most common sense thing. It's the implementation can really get sticky very quickly. Not that it can't be drafted through, but those are the kinds of challenges that the lack of communication, I think, causes unnecessary sort of confusion and even suspicion.
And you want to finish, then we'll go into what it actually looks like in the ground. I think we're going to come back to a lot of this and actually what can we do to move this, like what can we learn from the discussion on the UK-US agreement, on the discussion on law enforcement, and see what could be some of those practical solutions or not.
I'll hold my last point. I would just add to the possibilities for safeguards. Again, back to that, it's not always about sharing data, i.e. moving data from country A to country B, right? There's some technical ways where country A can actually maintain access to the data and allow country B to ask questions of that information, right? In the sense of country A hasn't lost control of that information, and they're actually seeing what kinds of questions are coming in and seeing the responses and have a bit more opportunity to be very confident and assured that country B is actually respecting, right, the agreement that they've worked out, right? Because once data's gone, we know once data's gone, it's in somebody else's database. You're relying on a lot of internal controls and other management safeguards. It's another thing to kind of still be holding on to the data, even though others may be given access. But I'll hold my.
And I think this has been great about the theory and your point about things like different in practice. What does it look like on the ground when you're working with the intelligence, the military, and you're trying to fight a war, particularly some of the new types of wars that we're seeing?
So thanks. I'll just stand up, and I'm sure I think my voice is good. You all have some microphones, but I think I can carry. There's a danger in following experts when you're not. And so let me just caveat where I will be coming from. And that is really as a military commander of an alliance and dealing with multiple nations, at least 28 in the alliance and many other very capable nations who are partners, who have very sophisticated approaches to both collecting and pretty sophisticated approaches to regulating how they deal with the data. But my view is very much a military view as a former alliance commander, and remembering that in that position, I'm focused on accomplishing a mission. So as Peter pointed out, there's kind of two sets of issues here, those in the protecting and those in the using. And in the using, I would say the category even gets more stringent in that our nations hold us accountable to multiple things. First, they hold us accountable to trying to maintain standards that have been very well discussed. But the first hue and cry that comes from the electorate of most of the nations that I represented is, have you accomplished your mission? Have you made us safe? Have you, in that personal pronoun of you, was very inclusive, because they would not just look at the legal authorities in our 28 nations and their partners, but they would look to the military. And they very much put us in a group to say, have you protected us? And that's the perspective that I would take. Let me talk just a couple of things about structural impediments, and then I will make some suggestions. And the beauty is most of what I really want to say has been touched on already. So I find myself in violent agreement with much of this conversation. The first one I think Peter mentioned already, which was immediately apparent to me as the commander of NATO. And I'll use just a small grouping of nations where we had intense pressure in collection and sharing of intelligence and digital data. And in the three nations that I first worried about who had come under attack in our alliance, plainly, as I dug into how I had to deal with those nations and try to improve their ability to deal with the problems they were facing, it became apparent exactly what Peter said. One nation, the mission was given about 90% to the military and 10% to their intelligence and legal frameworks. In another nation, it was about a 50-50 split. And in the third nation, it was given 90% to the legal and judiciary frameworks and 10% to the military. And so I had to create a framework by which these three nations, and they just represented the larger alliance in that every nation, as Peter mentioned, takes a little bit of a different approach to this. But we had to create frameworks in order to accomplish the mission. Remember that no matter what the construct of how we approach the legal and judiciary use of data, the expectation of the electorate is the same, and that is that their judiciary, their legal, and their military are going to protect them. The second thing that I ran into quite a lot is that in all of the nations of my alliance, to a certain degree, and in some of the nations of my alliance, to a large degree, there was huge internal competition about how this process was going to work out, because what it meant was funding. Would funding come to the legal and the judiciary, or would funding come to the military to address these issues? And what this created was what I thought was unhealthy competition inside of the nations in order to get access to this funding. And that competition for resources manifests itself in what I would call incomplete sharing. That then manifests itself into limitations on how we who are held responsible could do our mission because we have this incomplete or imperfect sharing. And frankly, while we are a great alliance and a great group of nations, there are certain historical boundaries that remain between some of our nations about how well they share and with who they share. And the Five Eyes is an example of a sort of an exclusive group that is completely inclusive within the five, but exclusive to others. And these things served as both helps and impediments to some degree. I agree completely with some things that Scarlett said and others about, I believe the approach for the users, not the purveyors of surveillance, privacy, or transiting data across borders, but for the users who are held accountable for the result of the mission. It was very straightforward that my other senior leaders and I would see a need for more standardization across international borders and how we approach this. More adopting at least a minimalistic framework by which we could all expect that level of performance between nations, as opposed to these wide variances I mentioned, which are really tough. And that these standards would, Scarlett was liable to jump up and whack me, but these standards would enable vice delimit. Again, the legal, judiciary, policing, and military functions are held accountable. Ergo, we would seek to enable vice delimit. And then I'm going to leave some of the things for Q&A, but I want to talk a little bit about a framework that we adopted. And I mentioned this to some of you yesterday in smaller groups. In the alliance, we had very capable actors in this area, and we had very accomplished actors in this area in the legal, appropriate ways to share and use data. In the alliance, we had actors that were relatively less capable at protecting data and using data and sharing data. And so the impetus was to try to get the alliance in a more collective way to help the nations that were struggling. This was a challenge because every nation, no matter how good they were in the alliance at what they did, they had their own internal problems, and they felt that their resources should be attached to their own sovereign and internal problems and not share their resources across the lesser capable nations. What we very soon found was that you can build a huge, I'm going to draw a civil engineering picture. You can build a huge wall or safe or magnificent door and building around your data. But in an alliance, there are 28 doors. And your door may be massive. But if your neighbor's door is wide open, you have problems. And so we finally began to see a more collective approach to understanding that when we work across international borders, we're only as strong as the weakest link. And ergo, we must work to not only strengthen our regulation of how we handle data, but we have to work on the structure of how we regulate data. And it became apparent that the smaller nations wanted the bigger nations to help, and the smaller nations wanted some of the larger nations to see that an attack in cyber or an attack in privacy or surveillance could be an Article 5 issue, widely debated. And so we came to a framework that is fairly simple, RCA, like the RCA dog. Many of you are too young to know about the RCA dog, but recognize, characterize, and attribute. Some of the nations FLAT did not have the ability to recognize that they had problems in protecting their data. And it was particularly unnerving when some of these nations would say, we're in good shape, it's very quiet. When it's quiet is when you should worry, because it's when you're not seeing what's happening. Then when there was activity, we had to characterize it as not of our nation or not a legitimate activity within our nation. And then after characterizing it as not legitimate or not of our nation, then we needed to be able to attribute the activity in order to bring collective capability to bear. And that last piece of attribute was incredibly important for the other nations of NATO to be able to help a nation that was struggling in these areas. So I'm not sure I cleared anything up. I think the main points of what, go ahead.
Yeah, but when you were doing that framework, are you using existing international military guidelines, or are you just sitting down with your equivalent in country to say, this is what we do, this is best practice, let's create this?
Yes.
Okay.
Yes. So we had experts just like this amazing panel that would grab the troglodyte F-16 drivers and make sure that we stayed between the white lines when it came to international norms and capabilities. We had to, our nations demanded it. But what we did do is sit down and try to speak very openly of best practices, and more importantly, the limitations that were placed by some of these odd frameworks by which some nations approach the business. And it was very hard. When you got a nation that does 90% of this in their military, talking to a nation that does 90% of it in its judiciary and legal frameworks, these are two pretty tough conversations to have. And that's why I applaud some of the thoughts that Scarlet and others had about trying to get to a more widely accepted set of standards, even if it's a minimal set that we can all count on in the nations.
I think there is one piece of certainly my perspective is from the intelligence into the military, so your perspective on the military might be different, but we have a pretty grotesque problem of overclassification. It's actually relatively difficult to get information from the United States intelligence community to the United States military. Most of their operators are working on SIPR, secret level computers, and getting top secret information over. I mean, we already have information sharing issues, so then expect the military to be able to rapidly, effectively share information with foreign partners. There's some really core issues that we need to address internally about the way we classify, handle, and protect information ourselves.
Overclassification was a huge problem. I think in the second subject that I hope to talk a little about, this became a very big problem when the Russians went into Crimea and when the Russians went into the Donbass. Our inability to share data and the inability of some of our nations to share data with other nations distinctly, and I don't want to give the next talk part away, but distinctly limited the formation of policy to meet the problems that we were facing.
I mean, how do you feel about that as a sort of scholar and commentator? That we have all these structures, certainly within the UK and in the US, and yet when it comes to international operations, where we end up dropping bombs, it is Phil and a few of his colleagues sitting around and coming up with a framework. I don't know. What about you? Do you?
Well, one thing that I thought was very interesting is that basically what Phil was describing as the need to increase sharing between agencies, across 28 countries at a certain level. I mean, that also applies. I mean, it's exactly what Susan was talking about, the evolution from the post 9/11 to the pre 9/11 to post 9/11 era was this breaking down of walls between different agencies within the intelligence community. I think from a civil liberties perspective, the question there is how do you maintain adequate walls when you're sharing, when you're moving not laterally, but to, for example, from intelligence agencies down to law enforcement agencies. And in the NATO context, you see that problem multiplied by, a factor of 28, basically. because you do need to increase sharing and have be able to facilitate that better between, for example, the militaries of these 28 countries. But then the question is, if that information then gets shared out to intelligence agencies, what's the framework within each of those 28 countries as to how that information might get shared domestically? I think would be the angle that we would be most concerned about.
And another complicating factor, I think, to tag on to what Scarlett just said is our militaries, as they collect intelligence, military intelligence, sharing with civilian sources of our intelligence or non-military sources, which are represented in the panel and so forth. We learn, and more often than not, the way that we understand how to share that is in order to affect a kinetic engagement in certain parts of the world, very much focused on these parts of the world where we are prosecuting terrorist organizations, etc., Daesh, ISIS, ISIL, etc. For the NATO alliance, who is doing that, almost all the nations, but most of the nations in certain parts of the world, they have to, in the same day, same space, and sometimes with the same intelligence and same people, understand that inside of our alliance, we're dealing with 28 sovereign nations who have the complete ability to do what they need to do in their own national space, own sovereign space, and it is decidedly not going to involve kinetic operations or whatever. It's really about building something that can be used by the legal processes to take care of the issue. And so it really requires a lot of skill and sensitivity in the way that we develop the intelligence that is handed to legal frameworks in an area where we're taking kinetic action versus in a sovereign nation and an alliance that has absolute ability and responsibility to handle this inside of their own nation state. So I may have just overstated the obvious, but it takes a certain amount of skill and agility of those doing this every day because they're working both stovepipes simultaneously.
Yeah, I mean, just add those that are working it day to day, are also set in a broader context of, country A in a, agreement with country B. Generally, both countries are kind of saying, I need to be getting something out of this partnership, right? Country A is saying, I want to give something, I want to give something. And each of them are kind of assessing at a generally pretty high level, much higher, I think, than people would imagine. Kind of overall, is this a mutual benefit? And so that means sometimes, decisions that might make complete sense, right, down at the tactical level, right, are, when you look at it from above, are kind of going, well, wait, we've given too much, right? We need to get more. So it can sort of complicate that agility because, at the very senior levels of the government, they're kind of thinking, right, is my partner, right, giving and taking the same way I'm giving and taking? And if there's a perceived imbalance, that's going to complicate the agility on the ground.
Does that mean sort of playing chess on three different levels at the same time mean that there's no way that NATO can think up some sort of overarching framework, and that it just would take away too much of the flexibility that you need, particularly when you are fighting the sort of hybrid wars that we have on at the moment? Or is this something that NATO is thinking about or should be thinking about in the same sort of debates we're having about mutually resistance?
Yeah, so lots of yes answers. NATO is working on this pretty hard and trying to build a relatively standardized toolkit, if you will, to approach problems in this word. You used hybrid war, and we'll just use that because that's the NATO word. But in these scenarios, trying to get to a standardized toolkit to be used is a definite aim of NATO. This is a statement of fact, not a complaint. When you deal with 28 sovereign nations who are approaching 28 sovereign ways of handling this, you get a relatively minimized, standardized set that are acceptable to all. And so learning to start from that minimized, agreed set of circumstances, and then be able to use different national standards to prosecute, meaning not prosecute in the legal sense, but to go after a threat or to go after either a terrorist or a criminal a stream of data. That's the real art of the science, is getting beyond those minimal things that can be agreed across a 28 nation alliance.
I think one thing that the current sort of political or headlines environment, I think more people have become aware of some of the features or sort of the cyber elements of the hybrid conflicts in a particular way that is very, very relevant to information sharing. And that is that we are seeing we're seeing countries operating with very slim levels of plausible deniability, right? That something about this particular landscape has allowed particular nations to feel like they can do lots and lots with, like a pretty narrow sense of, everyone knows it was you, but wink, wink, nudge, nudge, you aren't going to publicly acknowledge it. Now, the United States has played that game as well in lots of different places. So this is entirely about adversaries. But the ability to share information to the extent that allied nations are all going to feel sufficiently confident to take kinetic actions where required, that's going to be an important part about the ultimate deterrence question, some of the most challenging questions we're facing right now. They're very complex issues that we spent a long time admiring the complexity of, and we are now out of time in terms of sort of making those decisions. And so I think information sharing, credible information sharing among allies, is going to become really, really critical here.
So if I could,
Yeah.
That's one of the grenades I wanted to roll. Can I do that right now? So
And we're going to come to solutions because I'm expecting you guys to come up with how to solve this very complicated issue.
So this is the perfect segue into one of the toughest things that I faced as the SACEUR. As Russia annexed, or I like to say invaded Crimea, and then as Russia went across the Ukrainian border into the Donbass, is this plausible deniability, and what I have called politicization of intelligence. And what we saw in this sharing of data and transparency is this plausible deniability, and a technique used by all nations, to include the United States in its history, has been that if you cannot deal with the policy implications of what you're being presented, then you deny the intelligence. In other words, as you know, there were people for almost 9 months saying those little green men are not Russians, and we all knew they were Russians. But the idea that of denying that they were Russians, or asking for more proof and more data and more intelligence, was a tactic in order to avoid collectively the policy implications of us all agreeing that those were Russians and we needed to deal with this issue. And right up until the point where right up until the point of multiple leaders, but certainly the head leader, agreed that yes, they were us, but they were all volunteers. We still had plausible deniability right up until Mr. Putin said that. And then again, when they went into Donbass, it was the same thing. They're not Russians in there, and we all knew there were Russians in there. But right up until the point again, when Mr. Putin said, yeah, we're in there, but we're all volunteers, and they're on vacation doing this. So we found a time where this transparency and getting agreed intelligence across the alliance was very much delimiting in what we could do in a policy or operational event. And I think that part of what we talk about is coming to that minimal agreed to set of standards in order to get to data that we can all then act on is really important to military community.
And so what are, in that minimal standards for you, what does that look like? Transparency being one of them?
So we are one of the most egregious countries, I think, in this business, as we talked about. We overclassify our intelligence, and because we could not offer some of the very clear intelligence to some of our nations because of this overclassification, we were not able to use some of our very best stuff to show people, listen, here's what we watched happen, here's where that missile went, here's where it was fired, and here's where it went back, et cetera, et cetera. Because we weren't able at the time to share that, it caused division in the alliance on how to go forward. And so I think there are several concrete steps we need to take. And that is take a little different approach to what intelligence we share, especially having possibly carve-outs for situations like the Russian invasion of Ukraine, so that we can get a better, sharing early. And then the second thing is, I think, as we have discussed here, just a more transparent, multinational regime on what is shared, and a more transparent regime of what goes from military or national level intelligence to legal entities. I think those are all the starting points.
And what for you would be the next step on document transparency?
Yeah, well, I mean, one way to approach it is from the international human rights angle. So for example, in the UK, we have this case going before the European Court of Human Rights, where we were challenging the UK domestic legal arrangements governing the receipt of foreign intelligence from the US. And the claim there was under Articles 8 and 10 of the European Convention on Human Rights, which are also reflected in the ICCPR and other human rights instruments. And the way that the Article 8 claim, Article 10 claim works is that any interference with privacy has to be in accordance with law. And that's basically a kind of transparency claim. And the European Court has elucidated pretty clear minimum criteria for what that requires. So it requires, for example, that you have in primary domestic legislation, you indicate what the scope of that interference is going to be in a way that's basically foreseeable to the public. And there's a couple of specific criteria there. So what the nature of the offenses might be, and the limitation on the duration of the interference, and procedures for storing, processing, collecting, and destroying the information. So that's one approach, but I think in a lot of places around the world, including in the US, we don't use that framework as a way of thinking about interferences with privacy, including in the intelligence sharing context. So I think another framing device might be like, I think this is something that Phil was alluding to, is a kind of bootstrapping approach. So considering which is a kind of best practices approach, but considering across, for example, a number of countries that are sharing, which country has the strongest framework, and then using that as to bootstrap the other countries at that level. Now, obviously, from a human rights perspective, that would really depend on what the regulatory framework looks like in the strongest country. And it may not accord according to human rights principles with the safeguards that we think are necessary, but that may be a more realistic, at least interim solution.
I think that there are, one of the things that's challenging, and maybe this is just from my own intellectual process on it, is sort of understanding what form of privacy is being discussed, especially as it comes into sort of the practical space. So the notion of sort of privacy as a broader, I don't want to say hypothetical or theoretical, like a sort of a much broader transcendent value that is shared by people everywhere, versus sort of privacy as an individual right of sort of control or mediation of people have power over you. And so this is one place in which the United States, we've focused a lot on protections of sort of domestic individuals versus privacy protections for foreigners, and that conversation has really been based on sort of, right, Americans are entitled to something that other people aren't. I think that there is an inherent tension in the way we talk about this, or we're missing something, which is people tend to think that data in the hands of their own government is the most that's the privacy protective thing. Because if they're in a democracy, they've set the rules, they're familiar with the system, they have redress, they're sort of that tends to make them feel sort of in the most control. At the same time, that's actually where the privacy violation, to the extent that it exists, becomes most perilous, because your own domestic sovereign is the group that can actually do something to you with the data. They can arrest you, they can prosecute you. And so your data in the hands of foreign countries that are looking at it for foreign intelligence purposes and have sort of a different set of mission imperatives there. There is a way in which it's a very different type of violation, and I've more sort of put it out as a question of whether or not it's not possible to sort of step back and think about the different layers of the definition of privacy, because I'm not sure that sort of those much broader values can be shoehorned into the operational or practical space, to the extent that that's the kind of framework we're thinking about.
So if I can put that, I'm trying to think of that in the way a military person would think of it. What I sort of said is, in the sharing part, I believe there are in extremis times where we should overcome some of our own internal impediments to sharing data. So we may have a norm that in times like Ukraine or 9/11 or others, we should break that norm and be much more prolific in our sharing. So the question, which I think Scarlet will come up out of her seat on, is, does that transmit over to the privacy piece? Are there times where the norms of privacy are adjusted in order to address these in extremis moments in our international history? And I don't know, that's more a broad question.
Right, and I can't believe I'm arguing this side of the debate.
Something
crazy is happening. I mean, I think the obvious response is, if you look at what's happening, for example, in France, where you declare a state of emergency and then you just keep having states of emergency. But as soon as we start to codify exceptions, then the exception sort of beats the rule, especially considering, the rate of attacks or the particular situation we're in right now.
I wonder if we also sort of have to look at the whole human rights piece, because whilst, in the mutual legal assistance and law enforcement side, we very much are focusing on invasions of privacy. If we're talking about war, and it comes back to your point, John, about use, I'm going to ask you about that. We're not just talking about an invasion of privacy, we're talking about use, which could lead to the death of people on the road. So is there anything in this sort of framework that we should be thinking about when it comes to how a country actually uses that intelligence? Because I don't think it really matters if it's Ukraine, Syria.
Yeah. I mean, I kind of come back to my second point. I think I folded up my paper, so there it is. Yeah, that was my second point. Which is that when you're working from one nation to another, right, as difficult as it is, as was said, to often tell exactly where military and intelligence and law enforcement, who's, who falls in which bucket, connecting intelligence to intelligence across a national boundary, law enforcement to law enforcement, I think is really key. I also think, just a little bit to pick up on some privacy and transparency things, in some respects, a lot of the arrangements, some of the arrangements between countries are discretionary, some are not, right? Where they are, and in many respects, they're both at the same time, right? So, the intelligence agencies of the world there's no law that says they have to cooperate, but of course they do, right? There's no way one can go alone, right? There's no way one intelligence agency has all the linguistic capability it needs. There's no way it has access to the information it needs to satisfy. But because of that, and one of my favorite sayings is, trust is the residue of promises kept, right? When you enter into a discretionary agreement with someone else, right, just as, for example, with the U.S. on the indirect participation, right, the U.S. is going to impose its own legal regime, and the other country is going to impose theirs, and you're essentially going to take the high watermark of those, right? No one's going to compromise, right? When right? When there's these agreements, for one party to suddenly essentially go off and be transparent about that agreement without the approval of the other party, right? That's the quickest way to not have the residue of promises kept. And so it's a little bit of a just sort of cabinet or a caution that, what we might wish for theoretically in transparency in these things may be a little bit more difficult to achieve than something wholly regulated by one nation's legal structure.
So I'm gonna
not to say I wouldn't want it, I'm just saying practically it can be difficult.
So I'm going to wrap up with one final question, Sylvia, and then I'm going to open it to the floor for any questions from you guys. But certainly in the mutual aid assistance and speaking US and law enforcement debate, we've very much pivoted on the US being central to this, partly because companies or large companies like Facebook, Google, Microsoft are US based. But this is also feels like an area in which the US is equally relevant because of the power and might that it has in the world. So is this an area in which you could see US domestic legislation leading the way and codifying some of those frameworks that we just discussed?
I think the answer is yes. I think, even just to add a detail to one of the points we talked about, which was, U.S. intelligence sharing or passing information to U.S. law enforcement. I think there's probably more aspects that's regulated than is sort of widely known or appreciated. For example, just to bring it down to brass tacks, if an NSA analyst were to go searching for a crime, right, that would be an incident of noncompliance because that's not foreign intelligence, right? So really the crimes they come across are incidentally, essentially as they're doing their foreign intelligence. I don't think that's widely appreciated. I think if you listen to some of the headlines, it's as if, intelligence gets to go search for a crime and then pass that to the FBI. Right? So there's these limitations built into just what foreign intelligence is. Probably, I would say, the underappreciated workhorse of privacy, just those two words, foreign intelligence, and the restrictions, right, of intelligence agencies to them. So it's maybe a detailed way of saying, I think there's more to the frameworks than first meets the eye, but probably it's a challenging explanation every time I try to do it. Susan can chime in with hers.
Yes.
Just doesn't, right.
I mean, I think possibly to the extent we're talking about intelligence to intelligence sharing or military sharing, but to the extent, it's a much broader question about MLATs or cross-border data in general. I think there is a little bit of a fantasy that the United States is going to set the rules here and they're going to incorporate all of these sort of democratic values, and we're then going to be able to export that around the world. I see companies in a relatively awkward position right now, and I think a little bit it is of their own making, and that is that we have companies that are essentially quasi-sovereigns at this point. They are like the East India Company of data, right? They're making decisions and exercising control and setting rules that traditionally only governments do. And that's great for a little while. You get to make lots and lots of money and sort of set your own rules. The problem is that has morphed into, I know sort of a latent term, and I don't mean it as a negative thing, but a sort of a PR strategy or a conversation with customers or users or the public that companies have sort of said, we're in this quasi-sovereign role, we recognize that, and so we are going to discharge this function to protect you, to protect your privacy, right? And they've taken on this mantle in very high-minded rhetoric and sort of a noble way. The problem is that in the world, in order to do business in a country, you comply with the laws of that sovereign. That's how it works. And so to the extent that multinational companies want to operate in different markets, they're going to have to comply with the rules of those countries. And now they can get involved in the legislative process and try and make sure those rules are sensible and rights protective. But as we see U.S. companies that need to operate in China, need to operate in Russia, I see a little bit of a sort of fissure or a train wreck coming as those same companies that have talked in these terms about sort of their obligation to protect users are also faced with the obligation to comply with the laws of the jurisdictions in which they're operating. I think that can be a very difficult thing for somebody who's sitting without sort of all of this context and background to understand, and there might be a backlash to that of, oh, evil company, how dare you comply with Brazilian law. How dare you do this? And, you know, that's the rules here.
I'm looking forward to talking about that panel 3. To come back to the US and what role it's got in this area.
Well, I was going to say actually that so Germany updated their surveillance framework, and as part of that update, they actually included provisions in domestic primary legislation relating to intelligence sharing. It's been on my list of priorities to really dig through the provisions and understand whether or not we would think that they were sufficient on transparency, safeguards, and oversight grounds. But I think that that's quite a novel development. And the point that I want to link that to is that Peter in his opening talk talked about the transformative, disruptive quality of tech in the MLA context. And I think that we need to recognize that that's also true in the intelligence sharing context. And it's kind of why we're in this zone where we are struggling to really understand what is the applicable framework. So at PI, we have lawyers and technologists, and we often disagree about things. And when we disagree, it's common to say, well, tech resides beside, above, and below the law, which they mean to say that we're right and you're wrong. But what I interpret that to mean is that tech has this incredibly legally disruptive quality, and that disruption takes a number of different forms. It can change how institutions make decisions, like law enforcement agencies, intelligence agencies. It can change how they apply the law. It can even sometimes require the substantive underlying law to change. And I think that requires, first of all, that there's some factual humility that I think lawyers need to undertake, and that they need to understand tech developments. But it also means that we do need to constantly reassess the current framework and understand whether or not it actually applies to the facts on the ground. In the intelligence sharing context, for a long time, so now, data travels bundled with, communications can travel bundled with other people's communications. It can travel along unpredictable routes around the world. And for a long time, we didn't understand that intelligence agencies were tapping fiber optic cables, for example. And now that we know that, it really changes the scope of our understanding about kind of how much information is collected and what kind of protections need to be applied before that information is used. And I think that's an example of where we're sort of in this new frontier, and that's why we are struggling to understand how to adapt the framework to those changes.
So what do you think? Can the US lead the way in this?
Well, being the leader of a 28-nation alliance, what I found was no one nation is going to drive 28 others. But there are thought leaders in areas that can then begin to build coalitions of the willing that become larger, et cetera. And I think that our nation ought to try to get out in front of this and establish norms, both in sharing and protecting, that then others can begin to adjust and either adhere to or not. I think we all should take an opportunity to try to lead.
Could open the floor. Has anyone got questions they'd like to ask this amazing panel?
We'll go ahead and let Andrew then.
Hey, so I have a question. I'm just thinking about this from the perspective of other lessons we learned for the MLA cross-border law enforcement context. And it seems like in intelligence context, people talk for the most part about sharing of data or non-sharing of data, but the data will be collected by states who have their own rules about their limits. And in the MLA context, what happens is that one state says to another state, hey, you're stepping on my feet. You have to respect our boundaries. And I'm wondering if they have similar conversations in the intelligence space. Does state A say to state B, forget sharing, you shouldn't be collecting over here? Can you talk about that? What undergirds it? Are there cross-border dialogues about it that could help us in the MLAs?
So there is an intelligence community saying that if it was legal in the place where we're doing it, the State Department would do it. But that's right, there's something inherently adversarial about the collection of espionage, and in international law there is the inherent right of nations to conduct signals intelligence, right? There are the laws within that. What we tend to do is have defined alliances, right? So within the Five Eyes Agreement, we have very, very strict and defined set of rules and regulations about what collection occurs and where. I think one of the outcomes of sort of the Stone revelations was forcing a conversation with allies outside of that agreement. One lesson I think that there is to learn in that is separating out the practical and operational conversations from the political conversations. So the conversations that occurred at the German political levels seemed really very heated, and there was sort of this clash of parliamentary investigation. From reading the newspapers, you would think things had really sort of gone off the rails. From an intelligence sharing and law enforcement and that sort of standpoint, those relationships, I think, remained as sort of rock solid as ever. So I think if there is one lesson to be learned, it's how do we allow the work that needs to get done to get done without allowing some of like the ideological or less productive parts of the conversation to sort of infect that. Not to say that they should just, people should talk and what actually happens should happen, but that I do think there's an important lesson there in recognizing those equities and recognizing the difference between the things foreign leaders might say, especially in the realm of privacy, or sort of these deeply felt rights, and then what they actually need to get done. The more we can just recognize that, put our cards on the table, I think the more like actual progress we'll be able to achieve.
If I could just add a tiny agreement or a large agreement and a tiny different slant, I completely agree that yes, there's some of that dialogue. It is primarily in the political application of the dialogue and not in the actual technical getting the job done. But what I see more is exactly the opposite. And that is that nations are quick learning that some nations have exquisite technical capabilities. Other nations have exquisite human capabilities, et cetera, et cetera. And what I see is a more robust conversation about how we can bring this together into a more holistic picture to serve the greater good of the alliance, et cetera. So again, sort of a military getting the mission done. I saw more of that conversation than what you described, with the caveat of the political set aside.
Yeah, I mean, I would just add, in addition to the kind of, stay out of my soup bowl, I'll stay out of your soup bowl kind of thing, there's also just there's a lot of commonality. I mean, every nation has their own specific care-abouts from an intelligence point of view. There's a lot of commonality, right? Like human trafficking, right? People want to know where that is so they can stop it among like-minded nations. So there's a lot more discussions, back to the general's point about kind of who's covering what area and how much can we rely, because, there's just going to be, some countries are going to be better positioned in terms of capabilities, in terms of access. And so it doesn't make sense for everyone to just sit in their own thing and try to do the same. Right? 20 people all looking at one topic. There's a lot of sort of carving up. And then you kind of have to, you want some not all redundancy is bad in intelligence, right? Sometimes it's nice to get two perspectives on a topic, just so you're not getting you're not a single point of view.
I think there is one more that sort of John kind of shook loose, and that's sort of the security dilemma lesson, right? So countries do lots of things, and Ben Buchanan has written about this in the cybersecurity space, but it's certainly true in the intelligence space that nations act in ways that they think are protective, and they're just in defensive interests, laying the groundwork for future things and sort of preparing them, and they're perceived as hostile or aggressive by other actors, and then we get into the cycle of escalation. In the MLAC context, it is possible that we are in a cycle not of escalation, but of self-fulfilling prophecy, that everybody else sees data localization like the writing on the wall, and so each country is moving to protect its interests in this space because they have really important law enforcement interests. And so by passing the laws or preparing themselves for the inevitability that the United States controls everything, or they actually are creating the exact conditions so that the lesson of both might be that there are bad feedback loops that can exist if we can't step back and recognize what's going on.
I think we should wrap up.
We're out of time.
Yeah.
Okay. Wow. These
That's
5
the
minutes
easiest
went
question of the
very-
day.
Could you wrap up,
sorry.
please?
Yeah. Okay, great. We're finished, but raise an applause for the panel. Thank you very much.
Thank you.